Welcome back. This is the Truth Morning Devotion on Truth FM 103.9 with the broadcast live from we studios na Ilkot na Freetown. One for welcome all we viewers and listeners from across the country and across the world. And also Leonians for the past 2 weeks or so, we all know the legal terms them, the interpretations of things them. Section, I'm sure, what's popular with we right now, Section 91, Section 108, two-third majority or simple majority. Now, Timbo world again at the different media houses them and even here. But this morning, forget the expert them, for can explain to me waiting this actually mean waiting up on a parliament and how for interpret them before the Supreme Court get a ruling. I get the pleasure, and it's a blessing as well, for get this kind panel this morning. So I'm Baja Tijansi. Good morning, sir, and welcome.
Good morning, Truth Media. Good morning, Sierra Leone.
So for today, I go say Milan colleagues, una give me that Milan colleagues, una give me that authority there for call una Milan colleagues. So I'll
carry on.
Me are the journalist lawyer today with Milan colleagues. Dr. Emmanuel Safafulai, good morning and thanks for joining us.
Thank you very much. Good morning, viewers and listeners.
Thank you. Chukwu Emeka Taylor, my very good friend. Good morning, Chuks.
Morning, Lamrana. Morning, viewers.
Honorable Usman Abdal Timbo, Mikoto, and Honorable, good morning.
Good morning, Lamrana.
Thanks very much.
You hear what he say? He call we, he greets we. He say, good friend.
So now I'm a big boy.
Just watch how this thing gets.
I'm a big boy and learned colleagues them. And something will join me on the line as well as Victor. But yeah, I'll start this conversation. Mr. Tijansi, you don't hear the conversation. I'm sure you don't follow waiting up on a parliamentary conversation, the amendment bill. What do you think about waiting up on a parliament? Forget a context, the voting and the speaker in ruling.
Well, I would say the proceedings that be a comedy of errors. You see, the Constitution are the most important legal documents in the country. They make they call the premier law or the grand norm. Now for all the other law there, you understand, they come out. Now like the mama of the law there. So when you change them, it's different from when they change other law there. Now I make section 91 where they talk about so say usually in parliament, any question we put to parliamentarians, you can pass them by simple majority. But before the section they start, it tell you about exceptional circumstances. It tell you say except usai this constitution say other thing. And the speaker put all usai the constitution say other thing when are the exceptions to that rule day, including section 108. But then he misinterprets section 108 because section 108 get two parts. You get one part when a section 108(2)(b), where they tell you say anything provision inside the constitution where you want change them, you get forget 2/3 majority. That's not general for all things inside the constitution. Then you go 108(3). It tell you say certain things then in this constitution we get for do with we the people then. Especially we write them. We protected. Where you not go just canon or you change them anytime. Pass, you get 2/3 majority would on the force because that enough for all three they change the constitution. But you put addition, where means say you for go before the president they sign now, you for go to the people them, make them vote in a referendum for endorse what in parliament don't pass. And this not for good reason. You know say the 1991 constitution come after the 1978 constitution when be one party state. We right for associate and we right for get choice per politics. So this constitution go for remedy that particular mischief day. Now make we put this so that in future, because the way we have been changed in 1971 to the 1978, you have been so abrupt, and we believe say constitution also for the change and 50 fatter. So now make them put and they say for change this constitution. Number one, any part panel, you forget 2/3 majority. Number
I just
two,
read that part.
then thing they win and entrench clause them. We they want them day. We not go just change and 50 parts. The people then forget say panel. Now in they go to referendum. But now I see the speaker misinterpret. The speaker take and say all within in that constitution they deal with section 108. And that no mean nothing. How we go call like a statement and day, you know, that statement will go confuse we all. It's ambiguous. You understand it? Because section 108 gets purpose. Within the side note, it tells you say alteration of the constitution. How for change this constitution? Now in that whole section they tell you about. And one part it tell you say you forget 2/3 majority for change anything pan. And the other part it tell you say you forget apart from the 2/3 majority, you take the thing go to referendum for change.
So now
they can now say all thing wey dey talk now within section 1083.
Let's just read section 108. It say subject to the provision of this section, Parliament may alter the Constitution. 2A, bill for an act of Parliament under the section shall not be passed by Parliament unless A, before the first reading of the bill in Parliament, the text of the bill is published in at least 2 issues of the Gazette, provided that not less than 9 days shall elapse between the first publication of the bill in the Gazette and the second publication, and B, the bill supported in the second and third readings by the vote of not less than 2/3 of the members of Parliament. 3A, a bill for an act of Parliament enacting a new constitution or altering any of the following provisions of the Constitution, that is to say, this section, the chapters them. So you're saying it could have been 2/3 votes on the one that were not so entrenched clauses, and the one that were not entrenched clauses now they get referendum for.
Yes, 2/3 vote plus referendum.
So what happened on that day?
What happened on that day, as far as me understand the speaker in ruling, was that the section only applied to section 108, and only that section and the one section 108.3. Now then forget 2/3 majority.
We're not to entrenched clauses.
We're not to entrenched clauses, and not to that the bill say. Not to that the provision section 108 say. As far as my own interpretation and opinion can go.
Okay.
You understand? And then the whole procedure may be baffled. Because I be really want to go home and watch what be happen, because I see am live. But as you know, I believe that evening they were go home.
Yeah.
And from that end I was morning, and that day I come back. Because I see where you go committee stage, where you go second reading. I see them debate before they vote. And me go believe say, you know, before you go committee stage, before now they even begin put the eyes and the dots, when I for don't vote, because it's under second and third reading. So I see they read them after committee stage. Now I see them put the question. Me believe say you understand, if I don't put the question even before you go committee stage, you know, because if I don't read the 2/3 before they begin put things inside there. And then another thing is, I read now in ruling they say in the refer this matter to Supreme Court.
Yeah.
Me don't know say I pull that power there. And if you even get that power there, it's too late in the day. You don't pass the bill. Parliament don't get nothing for do with that bill there again. The only person will get something for do with that bill there right now are the president. No section other than the constitution will me see where say Parliament can make reference to the Supreme Court. The only person will me see there now the proviso section 122, we say the president by petition can refer a matter to the Supreme Court we get for make final decision for judicial opinion. And this is now one such case, because right now we all confused about the procedure where they take pass this bill and the authority of the bill, because you see authority is crucial now. If the Parliament not get the authority, and what they get the authority now we pass them by 2/3 majority. If the Parliament not get the authority, then under section 1038 it's treasonable. If you pass law where you not get, or if the Parliament pass law they not get authority for pass, that's treason.
So in this explanation look tricky somehow. Honorable Gevao was here alluding to almost what you say. So say you no understand who that go refer this matter, because the speaker not get the.
You not get her.
Not the speaker not go there. So who that
the only person now can refer this matter and me go advise them for do that now the president. because this is a serious constitutional crisis today, Panso.
So what in the
Because
speaker
if you-
refer is saying an interpretation on how then they vote moving
Yes,
forward.
before you go to Supreme Court, you get forget legal basis. We get forget what we call locus. What are you standing for that? You understand? What you give the authority for do that? Yes, the speaker on his own as person, Singapore, na Sierra Leonean, he can go to the Supreme Court for anything. Me self now, we all know can go to the Supreme Court for anything. But as Speaker of Parliament, you know they go there as a Sierra Leonean, they go there because of his office. And they carry the institution, that is another arm of government. You see, we get separation of powers. We get parliament for make law. Judiciary na for interpret law. The executive na for make sure say they implement the law them and at the same time and provide we with all the basic services in the country. So now they all they watch themselves. They all supposed to be checks, what you call checks and balances. You understand? Then they check, then they check, then they check. Now you don't make law. When you don't make the law done, you don't done. You understand? That man 9 days for interpret law. You know they make you law that you say to that man they will interpret the law, may tell you how to make law. That don't unbog the separation of powers as far as me concerned. That now one of the good reasons then where I think to say, you know the inside that constitution they say in King Ifa. But the inside they say the president, the executive, when he need guidance, because not when they make the law, in implement it, they implement it. In implementing is when he need guidelines, how for implement it. He can ask the judiciary when at the interpreting organ for interpret that particular thing and advise them.
Dr. Emmanuel Safabda, are we more? I'm getting more confused today with this explanation. I've been get Honorable Gevao Naya, and I've been on get Adi Naya. We've been on get this conversation, but it looks like there are other parts to this. Where I don't hear from Mr. Tijan CTD, but you've been there at the way, right? I remember you've been there. You follow this process throughout. You think what the ruling and the whole process was done constitutionally, following the right procedure?
So thank you very much. It's a very important but difficult question we ask, and in fact, I think there are a couple of things I want to say before I answer that question. So I just want to clarify something. You remember we've been there the last time when I said I think it's important for us going forward to have a 7-year term. Certain sections of the community say, let President Bio get 7 years. That's not what I said. You were here.
Yeah.
I just want to make sure that is very clear because I know people have run with it. In fact, then they put it on the social media all. Remember, for example, there are 2 posts where I don't see. One was from Basita Michael, putting that comment into a very narrow perspective and say, now because President Bio wants 7 years, I don't want an extension of President Bio's term. President Bio's term is 5 years on this constitution. If we amend this constitution according to the ECOWAS treaty and practice enough of benefit from them, now going forward, that was a conversation that we had. I just wanted to make sure that it's very clear.
Make that clarification.
That's out there so people go stop. I think what Hadi Macaulay and Basita who went public misconstruing, even though Hadi was here. The second part is before I also answer the question, I've said many times the problem we've had is because we amend this constitution in piecemeal. But also, from which we don't get over the last 2 weeks or so, it actually shows we that this constitution needs an overhaul. That we don't tear the chapter by part. It is time for us to really sit down as a nation without any political action and amend the constitution as to how we want the governance system to be. Because if we not do that, we are going to have this conversation. So I also want to say this procedure, I agree with most of what my senior Mr. Banja Tijansi say, except that I don't think if Parliament they didn't work and in the process the mistake it could be treason. People are taking this too far. You
consider what happened as a mistake?
Yeah, it could be a mistake. It could be an error. It could be a misinterpretation. A judge they misinterpret law. Lawyers they go say wrong things in court. Doctors they mistake. So you cannot say it's treason. Even watching the spirit of the constitutional provision really mean is when you completely get out of hands and try for misinterpret the constitution, then you can. You can.
But the speaker is a lawyer, right?
Yeah, but the speaker not gets not a. I mean, Banja Tijansi made the point. Speaker is not a judge. It's not a judge. We for begin to talk rule on issues in extenso, like that deep one day. So it could be procedural error, but it cannot be treason. That's what I want to make. So let's come to the question we ask. I think, say, the procedure towards doing this, now you get boku question. One, how do we interpret 108.2b? That interpretation is not as clear as people want it to look like. Because one of the things is, it depends on what you want to do. If you want to use the text alone, just now we're talking to me, Mr. Chukwuemeka and Mr. Timbo, they talk, and Mr. Timbo said, will look at the effect of sections 91, the effect. So you are not talking about text. If you go strictly by text, it takes you to absurdity. So when you read constitutions, you have to read them holistically. And then what is then called harmonious interpretation. The constitution say, for let parliament begin doing work, you need a quorum. The constitution did not create any other side way to talk about quorum. The quorum, now 1/4 of the house. Now the question you want to ask is, when that quorum form, when then they do that work, they are what? They are the members of parliament?
Yeah.
Okay. So why are you saying that down the line, the members of parliament now means all members, where the constitution not put all? In countries which are they want to use all, they use all. Kenya, Uganda, Zimbabwe, they use all members. You understand? So what you have to say is, this interpretation is not as clear as we want for let it look like, say, oh, what they did is so wrong, it is so clear. The constitution say the members of parliament.
But Dr. Abdullah, which I want to get in context first.
Yes.
You agree what was done wasn't right?
In most instances, it wasn't right. Let me tell you where you will see. There were, the way you say, comedy of errors somewhere. And if you watch me in parliament, you could see I was moving, talking to people. Now, just saying to people, I think this is it. Why we not go look at this way? Firstly, we just disagreed outside that if you're voting on the clauses, you don't need 2/3 majority. So when the APC worked out on that basis, it wasn't correct. Because go say, if we take this document, we say tono for there, now is for there, you forget 2/3 vote on them. And a simple majority. Now, then we come to the issue where, and it's also based on the fact that Parliament has done it repeatedly wrongly. You understand? Which is it the 2/3 of the members present, or is it 2/3 of the entire member, the entire house? And because they've done it in the Lara case, they did it in the speaker case. It's already in
they vote for the speaker
case. So they went with their own practice on it. Is it correct? Maybe not. You understand? So you could see that there were several mistakes done based on the political convenience of the day. But what I am saying here is clear.
It's not reasonable.
First, down there, I disagree on that, and I respectfully disagree on that. But the second part is, if you have a quorum in 89, when you constitute in the quorum, what are you? Is it the House of Parliament? It's members of Parliament, right? And I said this because the United States Supreme Court don't make a ruling on their own section of Article 5, where almost now the same provisions we and then get. They say, no, it is not. And I will quote you the case. The United States Supreme Court said, no, it is not all the members of Parliament.
Now the one that we
the one that we did. U.S. Supreme Court. Yes, when you reach the Article 5, it said both House forget 2/3 when they vote on amending the Constitution on a bill. And they did a decision twice where they said, no, it is not all man. Because if you say all man, 10 people will come together and say, we are not going to vote on that matter. Then you hold the country and the amendment to ransom. Because you cannot get the 2/3 of everyone. Or somebody sick in not come, or 2 people sick they're not come, they're not give excuse. Where then you cannot get to the fixed denominator. You understand?
Yeah.
So the point is, let me not say this is so clear. It is so clear. No, it is not. If you read the Constitution holistically, you will see say what they've done. In fact, let me talk to the third part before you interject. When Parliament itself realized that 1082 get problem, what did they do? In the Parliamentary Act, what they did, they added all. A difference. They added all to section 43.3. They added all to it. Why did you add all to sections 43.3 when the parent body, the parent clause in the Constitution 1082B not get them? Because they will not say there is already a drafting laziness when they do the Constitution. Because what you do is 1082B left the room for multiple interpretation. If you want to read them by text, you can say, yes, I want to go this way, which is simple. It forbid the whole house. But when you compare them, you understand. But finally, what did the Indians then do? The Indians solved this problem. The Indian Constitution, it blend both. So it said 2/3 of the house and 2/3 of the members present. In one breath, they brought both together
For address
that problem there.
Okay, let's bring Chuko Emeka into this. I know me and Emeka don't get conversation plenty time. You always tell me, say, and I see that in this. You've been on the remind me, say, the Constitution not a problem. Now the interpretation of the Constitution. Who interprets it and how they interpret it. You follow the proceedings. What do you think about the interpretation? You don't hear it from you two learned colleagues. What do you think about waiting up on a parliament that day and the interpretation of the Constitution?
Well, I'm glad the way they can vindicate me at the public space. What talks in the Constitution, a very good book. I mean, you need for tweak them here and there when problem arise. But if you're not broken, not try for fix them. Listen to my colleague, senior colleague, Banja Tichansi. I agree with them. I mean, in the entirety and the interpretation of 108, I agree with them completely. I also agree with Dr. Safa Abdullahi on one point we talk about treason. I mean, this way they talk about treason, that echo of treason cannot be treason unless certain things benchmark are met. So you can't, first of all, a judicial function only for determine whether something is treason or not. And secondly, when you look at what the Act say, that 108, you say any suspension, alteration, or repeal of this Constitution other than under the authority of Parliament shall be deemed to be an act of treason. Any suspension. Has the Constitution been suspended? We talk about a situation where coup d'etat, they say we suspend the Constitution. In this instance, has the Constitution been suspended? The answer is no.
No.
Second, alteration. Has the Constitution been altered? No. The Constitution will only be altered when it becomes a bill, when it becomes an act of Parliament. Now you alter. I mean, we can certainly decide, say, we want to change the Constitution. Emmanuel Safa Abdullahi say, instead put X under. Mr. Banja Tijansi say, Doc, put all our X under, put Y under. We certainly we can change this whole text now, alter now. And I mean nothing. It will be treason unless we put it into fruition. And then it will only happen when it become an act. Now make I always done the say for the last 3 sides where I go.
Who's are they right now? Because
it's a passed.
Yeah, the speaker said nobody no go.
But it not turn law yet.
Until the president can assent.
Yes, it will only be altered. Therefore, this is important, and I point I will stick me a pin on. It will only be altered when the president put the assent to him. As it is now, it's been passed an alteration. Let's put a proposal for the alteration there on the floor. Parliament don't make a proposal, whether on good authority or not. Parliament don't make a proposal. The only person who will make this thing pass into law now the president. And if he refuses, he therefore come back to Parliament for a 2/3 majority where they all go decide to not listen to him with the person. So it is far from being a fait accompli.
So if he gain assent.
If he gain assent, then we will go for Senate. It will be altered. And waiting make it be altered. Who are responsible for alteration?
That the issue, the conversation about treason.
The conversation about treason come in. I'm going to say premature now. And it hasn't been repealed. No, nobody not repeal the Constitution yet. If you go court today, we will use the book. What should they use? Now this. Which provision did you use? Now this.
if I want quote the law now na this in an unamended form. So no alteration happen yet, no repeal not take place yet, no suspension not take place yet. When we get the MPRC coup or the other coup d'etat, the first thing that you do is suspend the constitution. That means we'll not use them against them. Alteration go only mean it's been altered, and for make people understand, this constitution has been altered 5 times before this one, not to the first time. This one, they don't alter this constitution 5 times. I mean, we don't know. I mean, they don't alter the provision we ever do the political parties registration commission.
Yeah,
they don't alter the one for the speaker, not so the qualification for the speaker. And then we make all of it, but we don't do. I don't write a book on them, so you can go look at the Oxford University Press on the Constitution of Sierra Leone. We mentioned all of that. So that was the issue where I get disagreement with with the general populace about the treason. When I agree with Dr. Safar Abdullahi. About what I agree with with Mr. Tijansi, it's very clear, but this one of the two forget argument about the effect of 108 of the Constitution. If you want to alter the Constitution, you want to amend them, 108 they apply. If you want to take any other vote within Parliament for anything, you get 91 with the work. Then I no brainer, I no starter for me. But what he say, where we not for gloss over, where I don't talk repeatedly, after that second reading, the process flawed. From the bill not to be passed, not to be signed by the president because the process of itself flawed. But the disagreement will get among Boku jurists, and outside the process, the flaw begin. It begin from after the second reading. After that second reading, if we don't take a vote of 2/3 majority of Parliament, the argument about whether 2/3 are in Parliament, the argument of whether 2/3 are out of Parliament,
the quorum where Dr. Abdullah
would have been taken at that stage. At that stage, now if we don't get the argument. So when I say the APC left we at a stage where it mattered most, was because we all be the look for say at that stage they will canvass the arguments there in the well of Parliament, not on social media.
But there they were arguing already how for votes, whether for votes on the clauses and move on, or whether na the general bill where go to the end and the vote.
That was at the committee stage. Yeah,
it was not at the second reading.
Not at the second reading. They don't pass the second reading. Okay, second reading we no know whether they take a vote. As
but to credit Honorable Abdul Kabo, when this sitting starts, I don't say that repeatedly.
Yeah,
he stood up, asked the speaker, say, let he explain how they get for pass this bill, how they get for votes on the bill. He made that point and asked the speaker for define and explain which voting pattern they get for use.
Yeah, but how did they get
as a second reading?
No. Where did debate start? I'm saying where did debate start? When the debate starts, I follow the starting of the debate. He stood up and asked the speaker before them proceed into the debate proper, the first part, for explain which kind would they get for votes on this bill. Okay. And the speaker said then go get to that point, and they put stick or waiting to the controversial points them, and it go address that later.
Okay, so low take and say that happened. And then I'm not gonna reason for disbelief that I mean me not get no dog in this fight. Okay, I'm not the APC.
Sierra Leone is your dog.
Yes, I know I'm a dog, exactly. And the Constitution 13 say we've all for be good citizens and participate in the democratic process. Alright, me not the votes, and I don't give reason why on Facebook page why not the vote on the election, and not the vote between Orange and Lem, where I not believe say any of them good for me. Waiting me the vote on, and they vote on the premise that this person or this group of persons they respect the rule of law. I mean a lawyer. Fundamentally, if I not see that sign there from you in your utterance, in your understanding of your role as executive, I mean I know the casting votes. So look at the clear. So I take what you say in good part, but me on as a listening public, as part of the listening public, I not see that clear definition that we had a 2/3 majority voting after the second reading. I mean, I not say nowhere. I mean, a certain Honorable Timbo can tell me, say yes, then we get a 2/3 majority, we pass the bill, for move into committee stage. Okay, into committee stage.
Committee not see that. I didn't.
Committee stage, now what to look at now. Dr. Abdullahi say, you know that language where you shall, not for DDO, it will be me. We debate that one day. I say no, I disagree with you. He say I agree with you. So, Mr. Tijansi, what you say? Mr. Tijansi go say, Ah, well, I think so goes, Mr. Abdullah. At that stage, 2% against 1, don't say, na me for the day instead of Charles. That's not voting. And that's therefore be by simple majority.
So you agree with Dr. Abdullah say the procedure, and Mr. Tijansi said the procedure itself was flawed?
It was flawed. Any jurist from anywhere before will tell you say it flawed. And we don't pinpoint one area we all agree on. Well, I hope so. I guess Mr. Timbo for Kanduam, Honorable Timbo, is that part, that second reading, forget a 2/3 majority. When you said agree, say nothing nowhere. So the process flawed. It go to committee stage. At committee stage, APC walk out.
Okay. And you got a different opinion on that.
Yeah, when APC walk out, and then look, I'm not myself, I not get dog in the fight. I mean, APC, they're the only people where they hold the flag for the populace, them and SLPP in the well of parliament. They represent the people. They don't represent themselves only and the political parties only. They represent us, the people. So the people are looking at the lawmakers for say yes, they're the champion, a good fight on behalf of we all. We want to see SLPP say this is not 2/3 majority for pass the vote. Why are you waiting the APC they say? Because some of we hold the view say perhaps a simple majority in the well in the who that get access to the well of parliament. Now then, so when they left, the debate one-sided. All SLPP get for doing, I repeat and back taking quote many side. I would also say we agree, yes. It moved to the reporting stage. So we be want at that stage, okay, lay we own voices, with voices of dissent, be heard in the well of parliament by we representatives them when have the APC in that voice day. Okay. Because then they get opposition to some amendments. And some of we they behind them. Once one so we're not just them like saying we're not doom. We people who they consult with. I get friends from APC, I get friends from SLPP where they consult with. Then get access we may not get. So if I say that this if for B, now my own view day, how I hear that they put that view day in the well of parliament. So when they walk out, nobody know they articulate my view. I make a right position paper to parliament. I've done that several times. If you want bill, I mean the only lawyer we don't do one for the bill for the legal practice on that so far. Okay, it go there. They don't call me. Say when they're ready, they'll come for go debates. What's my opinion on that? But in this constitutional amendment, I don't get that kind of access there. So when they walk out of the well of parliament, okay, it kind of offend me because they not articulate some of my position they for articulate.
Honorable Timbo, Emeka say you una not for being the walk out. This is a procedure one for me not be part of and argue and make an point none.
With all due respect, there are many things where I want for.
Yes, you will.
Others, but I want for respectfully say what he says or not to the fact. In the sense, we're not being at that stage when a debate will be in a debate. We had passed the debate stage at the second reading and even the third reading. We don't debate every clause of that Constitution Amendments Bill, all of them. What will be for come back to? And the part they will stick pin on. That will for come back to for take a vote on them. Now make you realize that when we got to that point, it wasn't about debating. We don't debate them. When we not be reach an agreement over the debate, now make the speaker say they put a pin there. They put a pin there. So the talk say we know the views of the people, them. We as the representatives, we deprive them not to so it be. And you know, everybody know that the entire bill was debated. That is why that day, the first thing we did wasn't debating again. No. Then go put the question about this, what you want and what you don't want. The only debate we come on that day, now whether there been 2/3 on a simple majority for amend a provision of the Constitution or in the bill, where they affect the bill. The second part we didn't talk about now that there was no vote for the second reading. I want for all to deny that. Thankfully, yes, I'm a lawyer, but at the same time, I get first-hand experience as a member of parliament, different from them. So there's the way how the votes in parliament now by collection of voices, right? Whether it's simple majority, 2/3, or whatever it is. So by standing order 45, and they show how then they vote by collection of voices. Now only when a division day, now you will say, okay, we now get a certain number. On that day, we will sit down till 2 o'clock in the morning. I was the last person. Was I? No, it was a third reading. It wasn't even the third reading. No, it was. Anyway, whatever it is, I made the last point. Then the speaker adjourned. Before he adjourned, he put the question about all those in favor say aye, those against say nay. We say all those in favor say aye, all man say aye. Let's say if some man must say aye. All those against say nay. There was no nay, there was no dissension. Meaning by the collection of voices, 100% of the members of parliament voted. When you go to the votes and proceedings, the record of votes and proceedings for that DD, on page 16 it is clearly written there that the question was put at the second reading, and by the collection of voices, 146 members of parliament were present. And when nobody now say nay, it is assumed that the 2/3 required was achieved. It then said the records of vote and proceedings on page 16. So for say we not vote at the second reading, it not correct equally. That corrects that. Also, on Safar Abdullahi point about the constitution not clear, even section 108, where we talk about members of parliament. I agree with Chukwuemeka. This constitution not bad. Now bad people, now people don't use that for do bad things and interpret them the way how they want for interpret them for suit them convenience. No constitution is perfect. We accept that. If it left to me, this 1991 constitution, we should not change it. It should continue as it is. You make amendments to it. It is a good constitution. Now, especially now with the country don't the way it is, so how people think, they think more political than they think national. Maybe this constitution only passed because not be one party system. So all man not be one party at the time. Now attempt for do this. What happens when a parliament this term? It will be worse the next time. So it will be very difficult because people look at this from partisan lenses. Now, it talks say when they say members of parliament, there's a confusion. Now one creates confusion. Or whoever think that way now one creates confusion.
Is it not about interpretation?
No,
How you the interpret them and how you the interpret them?
I did not say that.
No, you said there's confusion.
No, I said it is not as clear as you think. That's not confusion,
So
and that's not clear. It's not the same.
Beyond clarity, first, in this constitution it provides where it talk about members of parliament present. It clearly says when it comes to the auditor general, it said for remove the auditor general, you need a 2/3 vote of members of parliament present and voting. It clear. It says when it comes to this, it said members of parliament, of the members of parliament. Thankfully, this same speaker now give a ruling on that. And he get this phrase where he use, he say without being vernacular. Like without not can talk Creole.
Yeah.
He say even ABC we supposed to understand that. When say in parliament, talk about prepositions, it means the one they present, they now. He say when they say of parliament, it means the entire composition. The speaker don't give that ruling. And I'm pretty sure that is why he not pass this constitution under 108 because he will not give ruling under 108 on 2/3 of members of parliament. Now make you go catch on a simple majority in the 91. Beyond that, let's say there's problem. Sometimes this same issue will not come up before. Section 94 of the constitution, when they talk about parliament regulating itself. Parliament not a jungle where they grab the money, no more say na so they go. We are guided by standing orders of parliament, in section 94 of the constitution make it clear. Plenty things within inside this standing order. If you get something for do with something within the constitution, then they take within the constitution, put inside this standing order. Now, we talk about section 44.3. I think it means standing order 44.3. It clearly deal with this, and I read down. It is under voting 44.3. a bill for an act of parliament to alter provision of the constitution shall, in brackets now, pursuant to paragraph B of subsection 2 of the entrenched section 108 of the constitution. Is where you refer to section 108. I say entrenched section 108. That means section 108, you know, they will change and waiting the inside it.
So apart from the constitution, this is the guide how na the vote.
Correct. Now this is the guide we. He say required to be supported on the second and third readings by the vote of not less than 2/3 of all the members of the house. What can be clearer than this?
So he's saying.
So what is the difference between what I said and what
those
you
who are
said?
there, right?
There is
that is the
there's something where you want for skip.
No,
Sorry.
Okay.
Let me
Okay,
interject.
clarify.
This sections 108(2)(b not get all. The totalization word, all. Sections 43 of whatever he calls it, standing order, he add all.
Okay.
Well, that's the point you were
That's the
making.
point. Why would they add all when the parent clause from the constitution, not the all? If you say all of these what they do, if they take from the constitution come, why you add all, whether they not get all?
No,
because you realize
So
that there is a defect. There is a defect in the 108(2)(b where you want for cure, and the 108(2) of standing order cannot enlarge constitutional provision. If you actually take them, it bring and can like what you do on all other sides. That's the point I made.
Okay.
I don't even know why you are disagreeing on it, and you just put it.
The points are that even when you go to case system in other countries and try for bring all this thing, I want to tell you, say there's no confusion here. For we in parliament, there's no confusion.
Okay, for you guys.
And beyond that, like how the man say, the speaker said, he say off and in are two different things. Of parliament, of members of parliament, do you have to put all? Do you have to?
But is there all in the standing
I'm
order?
just telling you, do you have to? So confusion, even as lawyers, we know say confusion or deep on that. And what you talk about, now when you say there's ambiguity, people will interpret them how they want for interpret them. We're lawyers. And I'm sure so we sabi English. Like how we say without being vernacular, we use them all the time. We not open Creole, like Creole they talk, but we say in an English word. Now the speaker don't give a ruling on that. So there's a ruling. All that we don't done, can't do this. Like I say, we say of all members of the house. If you dey on suspension, you sick, you go work and do, you go on official assignment, do you stop being a member of parliament just because of that? The full complement of the House of Parliament is 149. And not less than 2/3 of parliament requires 100 or more votes of the members of parliament. Then are 2/3. Say comedy of errors. I want to agree with that. But I want to also agree, I totally agree with waiting we learned senior and I say Solomon Banja Tijansi in entirety. Including the part where you talk about treason. And I also want to agree with Chukwu Emeka. Say, he not reach that stage yet. But he not denies an act of treason. You know. Until the president pass him. These are still proposals. So I'll tell you, the bill still in parliament. Why? Who constitutes parliament? Apart from the members of parliament, the speaker is part of parliament. The president is part of parliament. So until the president when a part in incapacity, the president assent to a bill, not to just as president, now still the parliamentary, the legislative process now they go so. So when the president pass up, when he sign and we assent him, then yes, it don't become law. So if finally don't reach the pathway
That's
talk
the
about.
issue of treason can come now.
Like how we say, participate criminals, they call them in law. So the one that participates by the criminal enterprise, it all becomes we all where they part of
Who
parliament.
determines that? Is it the case where you dey take go Supreme Court for determining? Because the
For
speaker is
determining
saying,
wetin the treason.
yeah, because the speaker is saying wetin he don do, no court no dey interfere with wetin he don do, and wetin he send na Supreme Court na for interpret how una dey vote na parliament moving forward, not on this sef.
I go help you. So there are two different things you ask. So whether the speaker that ruling said it cannot be inquired into, whether than they right, but on the treason part, now only the court now get right for determine whether something not be treasonous or not. They say an accused is presumed innocent until proven guilty. We all can make them kind of statements there. We all can make whatever allegation we want for make. But at the end of the day, the court has to fend that person there or people and they guilty.
So that they carry that case they go.
We not reach that part there yet.
No, but you know say you dey go Supreme Court. So I'm asking.
You are different. You know,
No, I'm asking now. So I'm asking, what you dey go court for? What you dey care?
Oh, now you're asking a different question.
Yeah.
So before I even talk about what they go court for, the speaker say in decision is final and cannot be inquired into. Number section 171(13) of the Constitution. I go read that first.
Me constitution too big, heavy. I know Ibulula.
So you pull and the compiled one.
Yeah. Now the one we get all
46 pages.
Yeah.
Section 171(13) I will explain first in Creole that nothing no day where they ask the jurisdiction of the court. Nothing. So I will read that for you. So anybody who feels a provision inside this constitution, they tell and say they not get power.
Okay.
The court not get power for looking to them. It's not correct.
Okay.
Section 171(13).
13, 172, 171, 13. Yeah, I don't see him. Graciously, Mr. Banjati Jansi don't give me in constitution.
From the most senior colleague. The most senior colleague.
Yeah.
It said no provision of this constitution that any person or authority, that any person like Senate or authority as speaker, shall not be subject to the direction or control of any other person or authority in exercising any functions under this constitution. What he may do so now exercise function under the constitution shall be construed as precluding a court from exercising jurisdiction in relation to any question whether the person or authority has performed those functions in accordance with this constitution or any other law. So anybody who feels say you know get right, the speaker, you know they will inquire into him by the court. It's not correct. Like he take and go court, in decision can be taken to court for challenge and say what he do so not they in line with the provision.
Now they go court for.
Allow I add for you. This myth about section 94 say the speaker's decision is final. 94(2) not a correct talk. Section 94(2) deals with the procedure of parliament. I dey read them back for you. Go turn the constitution. You know so you're a lawyer.
But this. Now which page?
94(2). Just look the section.
76.
This is new law.
This consider Yagba people. 76. Okay. I think I don't see him. Yeah, 76.
You go backwards.
Now
94.
94 today.
94. Go up.
Section 94.
2.
94.
Yeah,
Page 76
Cancel.
correct.
Yeah, yes, I did. 94 2 now the fair now. Section 1
Did they write up?
Right up.
94 1, 94 2.
But I go. I go the fair now.
No, but not ask for fair.
Honorable look.
You have to page 76.
This legal work we want take. Well, logo because of time. No, they go no more. Okay. Thank you so much, sir. Thank you so much. I mean, okay, I don't see him.
Okay. So okay, 94 1 talk about
Yeah, subject to
Parliament
provision.
will regulate its own procedure, right? It will regulate your own procedures through standing orders.
Yeah.
In fact, for you amend the standing order, we're not just sit on a parliament some one day we amend them. Yeah. Okay.
So section 94(2) say, notwithstanding anything to the contrary in this constitution or in any other law contained, no decision, order or direction of parliament or any of its committees or the speaker, these are the major part, relating to the rules of procedure of parliament, relating to the rules of procedure of parliament, or to the application or interpretation of such rules, or any act done or purporting to have been done by parliament or by the speaker under any rules of procedure shall be inquired into by any court. This is very clear for you, notice so?
Yeah.
All what they talk about are the rules of procedure.
And not the constitution.
Regarding any acts done by,
Yeah.
it's not just rules. There's another clause.
Okay, you take that. No, continue.
No, you read that.
No. Which section? I can read
The
that.
same section.
Okay, it's same section.
Okay.
I can read that. So notwithstanding anything,
Then let me explain that.
anything to the contrary in this constitution or in any other law contained, no decision, order or direction of parliament or any of its committee or the speaker relating to the rules of procedure of parliament or to the application
relating to the rules of procedure of parliament.
Yes.
That's one clause.
Yeah.
Yes,
One.
or to the application or interpretation of such rules.
That's the second clause.
Yes.
Interpretation of
But
clause
still
or
rules
the
of-
application
the
of
rules of
clause.
procedure.
Yes.
Which is what you want. That's
Yes.
Let's go, Timbo.
Or any act
You are
done,
taking so long.
or any act done,
Yes.
or purporting to have been done by parliament,
Three and four.
Wait.
That's instances.
No,
Yes.
go on.
or by the speaker under any rules of procedure.
So it's everything. It's not just rules. It's rules of procedure. Acts done and stuff.
The rules of procedure. Ask all other three lawyers.
The rules of procedure.
rules of procedure.
Just done under the rules of procedure.
It's under the rules of
It's not the rules of procedure. What are you saying? What are you saying? I'm deceiving. Shoot,
No, but if you shout without shout here, there will be no decorum. It's included of acts of parliament. Rules of procedure. Rules of procedures. Now they lead to actions. Why are you shouting? For what now?
Gentlemen. So simple majority, we can vote on this on simple. You are saying the act, the constitution is
Even
included.
under the rules of
Instead of
procedure.
rules of
Please.
procedure.
Please, we have sat here.
Continue
For
talking
7
to the
minutes.
host.
You've spoken. Nobody is interjecting.
No, okay, it go
It's rules of procedure.
Okay.
It includes. Go
ahead. You have the floor.
I mean, it's rules of procedure. He has access.
Listen.
You carry on.
No,
People don't understand.
I am
what
here.
they talk. We're here to educate.
Dr. Abdullah.
So it's important.
Dr. Abdullah will come and close. I just want you to clarify the
Who
point.
stops me mid-air?
No, I'll come to Honorable Timbo, the council. You can't close down. I just want to clarify what you want to say.
Now, clearly what I'm saying is it's not just about the rules standing on its own. The rules, now they dictate the actions of the speaker going forward. So in that, I start counting 1, 2, not to just rules. It says the actions of the speaker or parliament itself. So the action of speaker and parliament itself is included. You cannot read them in isolation and say in not day because now rules of procedure. The rules of procedure is governing the actions of parliament and the speaker.
So you agree, say the action of the speaker cannot be inquired into?
Basically, I'm not saying in this context. I am saying you cannot just come and sit here entirely and say anything we'll do in a parliament is questionable when the constitution is saying things and you go do in a parliament because they want to forget parliamentary autonomy. You know, go question elsewhere. Because if you begin to question anything with parliament to do, then it means that you disrupt their process. Politicians will use it. They will abuse it when they are not happy about it. That's why the constitution and the drafters do not fall. Then begin for name action number 1, action number 2, action number 3, adjectives and verbs, and then put them. Say when you do this, it's not questionable.
Okay.
You understand? That's what I'm doing.
I've got your point. Honorable Timbo, you get the floor now for clarify and make your point.
There are two seniors. I think the only person as senior for now, but there are two seniors. Let them explain what they understand.
No, they've made their point. They will make their points. I just want you
On this particular issue. So that was my last point.
Okay.
Yeah? So it can be inquired into. And the myth say a decision of parliament cannot be inquired into, not correct.
Okay.
Especially under section 94. And my points to that, section 94 got to do with rules of procedure. That cannot be inquired into. If the speaker do an act under the rules of procedure,
it can be inquired into.
It cannot be inquired into on the rules of procedure.
Okay.
That's what they talk about. And that is what I said.
Emeka?
No, I agree with them on the rules of procedure. Say 94 restricted to rules of procedure, interpretation of the rules of procedure, and as Dr. Abdullah say, we have about 3 limbs, but all related really to the rules of procedure. So it says, and we'll take it slowly, no decision, order, or direction of Parliament or any of its committees or the Speaker relating to the rules of procedure of Parliament. Substitute that for standing order. Okay? Or to the application or interpretation of such rules. Substitute such rules as standing order as well. Or any act done or purporting to have been done by Parliament or by the Speaker under any rules of procedure. So anything you do under agreed SOB, okay, those procedures cannot really be inquired into by the
Supreme Court or the court.
And like the same, if we do an analogy, I don't know if they go agree with me. I mean, when president need for consult and not consult, the constitution get under immunity. The back say, you know, the question of whether I consult or not will not be inquired into.
How we consult.
Or how we consult cannot be inquired into.
Okay.
So there are provisions in the constitution where actually they say, if you follow this path, no court will inquire into them. But if the speaker violates substantive constitutional provisions, then clearly the constitution, of course. I mean, if he misinterpret constitutional provision, if he exceed in jurisdiction, I mean, obviously Supreme Court the jurisdiction cannot be.
We most learned senior.
Yes, sir.
Mr. Suleiman Bajanti, what are you ruling on this?
I support what Chukwemeka say. I mean, the rules of procedure, that section that they talk about, that any action we take and anything we do as regards the rules of procedure, you can't inquire into.
Thank you.
But generally, I mean, this is not a constitutional issue. And the Supreme Court 91 green day for interpret the Constitution. So if the speaker take anything where anybody feel to say you are unconstitutional, you can write what you can go court. And Mr. Timbo don't quote the section of the Constitution, we say that perfectly.
So simple majority, should we say?
You're going back to
one thing I want to understand, where I want to understand, because we don't talk now about this second reading. Mr. Timbo said them votes. The question was put during the second reading. If the question was put during the second reading, then they get 2/3 majority. Then nothing having the argument about, because if we don't agree saying a 2/3 majority at the second reading, then at committee stage we don't need to agree again on 2/3 majority, because 2/3 majority is already agreed upon. Committee stage now for just tweak around the corrections. So I want to know from Mr. Timbo why the workout really, because as I said, I was distracted that day because I became very and all that. You know?
Yeah, Mr. Timbo, we really want, because that's not the first question I asked, the workout. Chukwemeka self question that, and Mr. Tijansi self don't question that quickly. We need to link to Elino quickly.
So on the rules of procedure equally, so people should not question our working out, because it's part of parliamentary process.
No, not the working out, it's the argument that led to the working out.
I just want for sure say we working out should not be questioned in zone, because now a way for show dissension.
Of course.
If we've been sit on there and not vote, it's the same thing. It's the same thing. We were present on that day and we were counted. That has been an important thing. So we were there. Now on a working out, maybe this is where the interpretation for come. Whether for amend a clause, a different now you can do a simple majority for amend a constitutional provision, versus whether amending a constitutional provision a different, you can amend by a simple majority because it's not a bill. Now for me, what is a constitution? This constitution, and call it a constitution because a compendium of laws. Every law in this, every provision in this book is standalone. Now we get them all. They made them call a constitution. They call them gun norm. The gun norm is put all together. Now, anyone where you want change inside there, let's say for instance, the presidential term, no, not say the presidential threshold. It's inside the constitution of 55%. You want for change them on just that one provision of the constitution. If you change them, not to the entire bill, you don't alter the constitution.
So you need 2/3.
So that's our argument. And now in section 1089 they say, if you want for alter anything in the constitution, a provision, it says there, a provision, anything under it, this is now the argument. Chukwu Emeka can get another argument. This is something we will ask the Supreme Court for interpretation on. 6 lawyers, 4 lawyers now, we all can get different opinion on now. Respect.
But the point he's making, on have been non vote before the 3rd reading.
And no,
Let clarify.
different thing.
Let clarify so Timbo can answer because myself, I'm in tendency there for make I agree with them so after this program. But becoming not to parliamentarian and they get the advantage there. Now, waiting me understand, and sometimes Mr. TJC self sometimes they have the same understanding. When they don't the merit, the second reading, and then the debate, the merit and the merit of the entire bill. This law, one amend this constitution not will not agree. If it pass, as he say, I mean unanimously, it means say they agree, say we for change the constitution. What that would they say?
Correct.
When they don't agree, say we can change the constitution, they move to another stage.
The committee
The
stage.
committee stage. The committee stage now, and for look now, the change. How we don't get the change they say. We will change and no using same example from 55 to 51. We all agree say now 55 to 51. At the committee stage, now the wording, the context of how they put that agreement into effect. Now we they agree on. So in Dr. Abulai go say, we not for use the word shall, we for use the word will. For give him the interpreters a flexibility, but they bring the threshold to 51. How will they bring it to 51 and how will they write them as 51? Now in with the talk about now.
So it's not an argument on whether we agree say 55 for the 55
no. I mean I think so we agree on that. At that stage they will decide at the committee stage. Let me draw the parallel first. For saying normally there's a legislative committee when there's something like 19 person where they make that decision there on the text. They can't work force it also. Or maybe 5. But this now be a committee of the whole house. Because it's so important, so I want to make everybody get in voice at that thing there. We all not go agree, as you say. We can never agree on shall, will, or may. So at that stage in committee, we get for take a vote. It can never, in common sense, be a vote of 2/3 majority. It will be simple majority.
Honorable Timbo clarify
So now take the constitution back. We'll our lawyers, yeah.
Section rating.
Ola number 1089.
1089.
See how they say 108, beautiful 108.
Yeah. No 108 I get an and they only then I'm phone safe. They all over.
Okay, take 108 first. Just take 108 and look at the side note.
Okay. 108. Yeah, so they go no.
Sorry, Mr. Timbo, what you say for look at the side notes?
Side note.
Let the listening viewers they understand, say,
Yes.
under the Interpretation Act of 1971, Act number 8, the side note not to part of
Part of
not
the
of part of
the guidance.
Exactly. A guidance number. So
Correct.
law does look and say that altering, not to for take like say na part of
You know the
No.
So like I said, I need the guy.
No.
Explain.
It's not explain more. It just did for make you pointer. Okay, but not a part of the marginal.
So they show you waiting there inside that part there.
Okay.
We're not deny that.
So the side note that the alteration of the constitution
alteration of this constitution.
of this constitution, yeah.
So take section 1089.
9. 4, 5, 6, 7, 8, 9. Yes.
Okay. In this section B, it says references to the alteration of this constitution. All that word constitution, a member outside the right corner say alteration of this constitution. Yeah. It says references to the alteration of this constitution or of any chapter or section of this constitution includes
references to the amendment, modification, or reenactment with or without amendment or modification of any provision for the time being contained in this constitution or chapter or section thereof. We'll take first the modification or amendment. Now they try to do so. Of any provision. So inside the right constitution now, like how you talk about substituting rules of procedure for standing order. Now so you substitute constitution for provision.
So the side note comes there, is that what you're saying?
So you will say now alteration of this provision.
This constitution.
No, so constitution change that to provision.
Provision.
So if you want to alter a provision in the constitution, it applies. So it applies. So wait till they try for alter now on that presidential term limit, now provision.
Yes.
So that means say now section 108 now apply.
Yes.
So if you are alter under section 108 a provision, it basically means you need two thoughts.
Yes, but from your argument, if you want,
It's not at the committee stage.
if you want alter any provision of the constitution, whether the whole constitution is small to and pull, you get to use 108. That's not the point.
And what you 108
I got to
right.
pass with 2/3 majority.
Thank you. Thank you.
Yes, we agree on that.
Thank you.
Okay, but what in the fail for understand, or what it in position not allow for see the clarity of waiting at the time for say is that when you want make an amendment to perhaps syntax, so perhaps words used, etc. Okay, not to the provision you dey alter at that stage. Not put it so you want alter the language for express the provision. Okay, you put it the language for express the provision. We don't say na 55. We don't agree in principle say na 51 now. We all don't agree say na 51.
So now they change from 55 to 51.
We don't agree on that.
Yeah.
That's not the provision. When a 2/3 majority will agree on that. Now, how do we convey what language
Do we
use for get that 51? All right. Now, he say that language will use for get that 51. That will be subject to another 2/3 majority.
In agreeing with Chukwuemeka, the constitution is clear as to when you take the vote for 2/3. It's a second and third reading. The constitutional drafters, they did not skip committee stage. They not skip them because they've been glad. But they took into context that at committee stage, now they want to go into the nitty-gritty of clauses, phrases, adjective, preposition. That cannot be 2/3. It's basically the way you say, we don't agree, say, would they amend this constitution, which Honorable Timbo said they all agreed 100%.
Okay.
Now we go into what would they amend. In that conversation, I was in Parliament and he alluded to it. What they did was put stickers. Say, okay, we not agree on this. We not agree. But at that level, go. There is 91 way basically say once it comes to those internal conversation, a simple majority. But the Constitution in 108 2B, it said we wanna go to the third reading, then we wanna take another 2/3. We wanna go to the second reading. It's keep committee stage level. So you cannot import that committee stage level at every time we will say that C not cross, it get for be 2/3. That I not get dot, it get for be 2/3. Because the constitution what they discussed and the same provision say second is keep committee stage and third.
We can't get a ruling on this from the most senior learned colleague now. Quickly, Honorable Timbo.
Yes. So let's tell you say even Chukwuemeka now for move from. And he don't agree with me, but he don't turn on. He talk about language and provision. He say if not language, but you don't need 2/3. But if not provision, you say you need 2/3. Not so.
If not substantive provision.
Correct.
Yes.
So what do you know
At the
understand?
second and third reading.
Yes. No. What do you not understand now? Now that, or what you know, it don't confuse me with now that. We're not trying to amend shall, is, or was. No, don't say that. Provision of whether not 55% or 50 plus 1.
You're going to agree or vote on that and move to the next.
No,
Right?
I don't agree. Say if you want amend a provision,
Now, two thoughts. He has agreed on that.
Yes.
And wait till we seek for amend. Who say they alter the constitution? Na committee stage. At second, who say they alter the constitution?
No.
Hold on. But you don't talk
Yes,
well, I mean, only in parliament.
But that was the procedure on that day, right? Also the constitution at committee stage. But Chukwuemeka, they say that should not be the procedure, right?
No.
They will take a vote on that day before it go committee.
Committee
But
stage.
he
That
said
is
they
what
did.
we did.
He said they did.
So let them say they agree on the 51%.
No, I wanna stick a pin to that and can't go to the committee stage.
No. Okay.
You're patient with me.
Yes. I will explain this.
Patient with me.
So the second reading, now don't debate the entire bill, whether it for pass or not for pass. We all agree that okay, this constitution, if for pass, we agree say they for amend the bill, they for amend the constitution. When you go to committee stage, then they cover the maze. Then they stop for refer to the speaker as Mr. Speaker, then Mr. Chairman.
Yeah.
So you know, so don't go to the parts now. We don't go inside the bush for go change the law. What would they at that stage do now? Every clause yonder stand on you because it alter the constitution. What is when they pass on them? There was consensus on most of them. So okay, this we agree, we pull this, we pull that. That was consensus. But when it comes to the one who stick pin on, then the speaker now say, but no vote on them. They're not supposed to be a vote. Votes not be supposed for the day. But because they don't become contentious, and now the effect of the way we are for amendment will alter the bill, will alter the constitution ultimately. We don't agree, say, let pass, like the second reading. Say, let this one want the amendments. Now you don't get something inside there we don't become contentious, so we don't agree. But the effect of this, if it comes to the final stage, it will affect the bill in pass one. Because if APC say, okay, because we not agree pull this, all the other things they get for pull, the bill not go pass. All the good things they would agree on, it not go pass. So what you do at that stage, because like I talk about 1089 every provision, because not to language you they change now, it was. Now the provision itself. That provision will therefore go affect the final passing of the bill at the third reading. That provision will therefore alter the constitution. If you want for vote on now, we point to that enough for be by a simple majority. Because the effect, let's say you pull them inside that building, you pull them inside this document. Okay, this is the easy talk now. You just take that 1 gram provision, you put them into another bill, pull her inside this. You take that 1 gram one day, you bring her in a separate constitutional amendment bill. How you pass her? A simple majority. Just the one provision. Now simple majority on 2/3. And what in this clearly don't show that if you amend any provision, not a language or sometimes you agree, sometimes you language this or was, now that day. But moving forward, based on your argument, wherever you go and talk about this, please tell people that if you want to amend the provision, you need 2/3 and it fall under section 108.
Okay, Honorable. Thank you so much. We'll go quickly our virtual. We can to we most senior learned colleague na the studio for get ruling on this. We get Elena Thompson. He don't do wait so long for Elena don't follow this thing. The last time in Parliament state to good morning, Elena. So they get virtual court.
Good morning, Lamana.
We know stick to just the studio session. Good morning, Elena.
Good morning, Lamana. Good morning,
Okay.
Salon. Lamana, Sisi, we don't
yeah,
get
yeah,
my
Balicia.
today for when-
Yes, Elena, Chukwuemeka say they are given. The Elena is here. Sorry, we don't keep you waiting this long, but I'm sure you don't follow the conversation. I know you followed the debates in the parliament, all the procedures them. We don't get diverse opinions now on this. Waiting are you on position on waiting up on a parliament on that day?
Thank you, Lamana. Good morning, Salon. Good morning, Tooth Media Fambulem. As I say, Lamana, Sisi, we don't yag by you this morning for where provision in the constitution. But I agree with different in a way me learned colleagues, learned senior, then don't talk. I will just pick out a few relating to their contentious issue they also way when I know the debate. The first one now whether at second reading votes been there on the bill and whether the bill for move forward. And whether whether that vote then have been by 2/3 majority. As Honorable Timbo say, yes, then take a vote. I've been a follow proceedings, I've been there in a parliament. But as it say, the votes have been by collection of voices. And you know they able determine 2/3 by collection of voices. I like nobody no object. I like you not get no nay. You know they able reach a quantitative conclusion by qualitative measure when a collection of voices. So you get a problem at that stage they self of whether the correct procedure then be follow am. And we get procedure then not to just now we lost them, but now the constitution for a reason, now for prevent abuse, as Milane Senior, Mr. Banda Tijansi don't talk. Now for prevent abuse and a push of authoritarianism. Then you come to committee stage. Now committee stage, as me colleague Chukwumeka Taylor and also Mr. Banja Tijansi don't say, you know they actually amend the constitution na committee stage. You dey determine the language and the final clause then we go dey inside the bill wey dey go vote on na third reading for amend or alter the constitution. As Honorable Timbo know, me don dey part of many legislative process then and I don dey part of legislative committee session them. Boku. Normally, yes, na the committee dey sit. This na been committee of the whole house because the constitution is such an important bill. But at that committee stage there, wetin na the work wey dem dey do? Wey even talk say speaker not to speaker again o. When you get committee of the whole house, speaker na chair of the legislative committee wey you get committee of the whole house. Na im make dem dey pull, you know, the wig and all thing for the committee stage, right? You dey determine say this provision go dey inside this bill. Or you dey say no, now this for be the language of this provision wey dey inside this bill. You know they actually alter the constitution at that stage. The only time where you dey actually amend the constitution na the bill where you dey vote on at third reading. And I understand the points where Honorable Timbo dey make, and also Honorable Daniel Koroma be also make this point during the sort of back and forth on this issue during committee stage. And Daniel Koroma now one of the MP there where I can look for you where it talk because it give me sense but it always make me laugh at the same time. It make the point very clearly say where you dey try for where if you dey do am clause by clause, you essentially dey alter the constitution. Or na a workaround for try for alter the constitution if you dey vote clause by clause, based on simple majority. But let we remember say at committee stage, you know they actually alter the constitution. All you dey do now for determine wetin dey go inside this bill, this document where at the third reading. Now that same day you dey make a vote for determine wetin actually they change, wetin they alter the constitution. So I think say we as much as that arguments where Honorable Timbo and Honorable Daniel Koroma make, it gets sense. At the end of the day, we get for understand say now make their voice them be so important na that committee stage. I don't dare now, even though you know the debates like how you dey debate during the second reading, right? But honourable Timbo sef know say some level of debate dey na committee stage, because you go get differing opinion dem and views on the various clauses dem. Normally wetin can happen, the different opinions dem can be put forth, some of we technical experts dem can give we own views dem, and then the whosoever dey preside, the chair of the legislative committee, dey determine, okay, wetin na the final decision on that. Most say not, I mean, not to vote sef you can get, but because this na committee of the whole house and APC, through the leader, leader of the opposition, insist on a vote on the individual clauses at committee stage, on then contentious clause them. Now it make we even get to the issue of voting at committee stage. So you get
Okay.
for understand say that dey not so normally wetin can happen, and so you no go automatically can impose a 2/3 requirement at committee stage wey normally no dey ever obtain at committee stage. The constitution clear say na at third reading,
Okay.
second and third reading.
Okay, Elena. Quickly, we'll go to Victor Lansana before we come to Mr. Tijansi. Victor Lansana gets a position on the interpretation of waiting the speaker say. Good morning, Victor.
Good morning, Lamwana. Good morning, everyone.
Yes, I'm sure you don't hear all the conversation this morning. And one thing where we start with now that Mr. Tijansi and Safa Abdullah and even Emeka agree say the procedure of how this whole thing happened at Parliament and the speaker in ruling, there were issues with it. Waiting na your own position specifically with waiting happened at Parliament that day.
Well, as you said, don't see this morning, right in that studio, Paul and they already he used them. That for tell you say there is a problem. But the constitution, I mean, I have to actually put a caveat or a disclaimer. I'm not attempting to interpret the constitution. My attempt now for make an opinion on the constitution. What's happened at Parliament on the 10th of August? I think really, I received them with mixed feeling. In the sense that on one hand, we don't see way out of Parliament. They actually, the Constitution with provision. So me expect say on that very day it was not to make actually come together and vote will succeed or fail. So that was why when the APC colleagues them walk out, for me it was a disappointment. As I'm like the walkout was premature. It was not at that stage worked out they should have. Because that stage they will therefore look at provision by provision in the bill. When they not come now at the stage, the actual stage after that committee stage, the third reading, who said it should be taken. Now they, I believe, say either they go work out, because by the way, working out now part of the privileges, it falls within the past. Any political party will feel satisfied of the process if you work out. But however, that was the stage. They could have waited until the stage who said bill will be put up for voting. Then that stage there, they stay and vote, and that voting need feel safe not be by way a secret ballot. Secret ballot or of hands or everybody stand they are giving one favor one so that everybody will be a head count, and then mathematically what's like 2/3 of the one them will present with it. Because all meant about 2/3 of members of parliament, really it becomes a matter for semantics. When you look at different tools the way court can normally use for do an interpretation, of legislation, you will find out say they not just use the literal rule where waiting before we look at or what how they use. But sometimes we look at the context and the purposive rule. Where for sure say, indeed, what be the intention or the intendment, how lawyers like you say, of the drafters, the particular provision or that section of the or in the constitution. So, for instance, if there are those where we say at all present, but they're not going to vote at all, whether they put this question at the times, or if there are others where just say 10 or 15 of them, not actually they in the country. So, are you saying that the House or the business of Parliament should be derailed because those members or few members don't decide not for vote, not for participate at all? Is that the way to go? Because 2 or 3 members don't say they are not voting, or 2 or 3 members they out of the country on an official. Are you saying that the votes don't for go on? So I said that that members of the APC they for don't stay and vote against the bill based on the fact say according to them there are provisions there inside the bill where they disagree with. So there is a clear distinction between the bill and the document taken as whole and these sections in the bill. And those sections they will try for now. I mean, look at vote on them as at the stage where they work out. At the stage where they work out, now where they will look at the search and nomination committee and the extant club, the current constitution. We talk about consultation, for instance, for appoint TSL boss.
Okay.
It was at that stage, but that is quite different for treats now. So that was the time.
Okay, we dey get some network issue with Victor. We'll come back. We'll come back to you, Victor. Mr. Suleiman Bajatijansi, you don't hear the diverse points as the most senior, learned senior colleague. Na I go say, what's in the most controversial issue with this interpretation? Is it about waiting Emeka say is about the constitution is not the problem, it's about how it's being interpreted from what you don't see in a parliament and what you they get now?
Yes, not true. Well, I make us say this for go for litigation. You know, I think the Supreme Court get for rule on these issues. 2 issues do arise now or the debate right now. This issue of whether or not at committee stage you forget 2/3 majority or simple majority. The section 91.
I got your constitution.
Yes, section 91 we talk about the exceptional circumstances. And 108 now one of the exceptional circumstances. So based on that, Mr. Timbo, Honorable Timbo is right that the fact that you don't move from section 91, you don't count that section 108 for apply, we say 2/3, you for use 2/3. But then again, me go lean towards what Mr. Chukwuemeka and Mr. Woden call the talk, because the constitution, where one makes something specific, they make it specific. Where one make it general, they make it general. And not say at all stages of the legislative process. It says second and third reading, as distinguished from at all stages of these proceedings, you understand? Which means to say he specifically wants 2/3 voting during the second and the third reading. And as such, as is silent on the committee stage, you go back to 91.
Can I just help?
You understand?
Sorry,
That's
there's
one.
nothing about committee stage. So let's just help this confusion people create. There's nothing in the constitution where they call committee stage.
Committee stage, no.
Now
Then
second
again,
and third reading. Now just a word.
Okay.
well, now I want candidate. Then again, I can say get for go for litigation. Then again, you look at the issue. Is committee stage part of second reading?
No, it's just a name.
Or is committee stage just a name? You understand?
For the third reading.
For the third reading?
No,
or is it part of the third reading?
but sorry, let me interject. I mean, let we not do this. Let we not do this about constitutional processes in parliament. From government at Form 3 to Form 4 to Form 5, there is a committee stage level.
That's
in
a
lawmaking.
reading.
Yeah.
Yes,
No,
but
no,
after that,
no,
there is a
no.
separate committee stage level.
No,
When you
but
come,
I tell you.
this is something they teach you in
Yes.
history. They teach you
No.
in government. Let's talk about even in Anglophone, Commonwealth, West African, African constitutional making. There is a committee stage level
And a reporting stage.
And that reporting stage. Even don't forget about constitutional law. Don't forget about constitutional amendment. Let's go to a bill. When the bill comes on second reading, the parliament, everywhere since I was a boy, the speaker will say, "I'm sending it to the committee stage." Which side then they go through them, then they brush them, then come with a report and say, "This is what we've seen. This is what we." That is the stage, for example, where they will call America and all that. So this not elementary government. I mean, we cannot disagree with that and now say the constitution, no, the parliament is not going to go to committee level and you say it's third reading. The constitution skip that part because you know say now detailed work then will get for do at that level. So committee stage exists in every language, in every framework of constitutional
And the
law.
reporting stage.
No, listen to
Yes.
that.
I want to explain constitutional process, parliamentary process afterwards.
You come. I'll come to you.
So-
I'll come to you. Yes, let's just get the legal aspect.
I know, they're not even confused me thought.
I know.
Sorry, sir.
Wow.
You understand? So what I try for talk is now I make I say again for this now one of the issues they will for litigate on. You understand? But me go believe as I say right here that before he refer to committee and what they call, and I think the committee stage not only for make the dots, the eyes and the Q's, when I did ever go tidy up and agree on so that because they can't third read in your now vote. So therefore don't agree because if you not agree to one or another, then it go drop because this na serious vote. A 2/3 majority. So that stage they would been there. So I make find am very unfortunate that they work out. Now that stage there you understand if you don't sit down and negotiate, you understand and sit down and agree. Especially the two controversial clauses, the one for do with PR and the one for do with the threshold for presidential election. Now let them if you don't sit down and really cancel what they call, but now they all team well. That now one meeting to say. You understand? It good. If this matter go before the Supreme Court, may then tell we. You understand? Waiting they mean. You understand? By 2/3 majority, second and third reading, and what role committee stage they should play in legislative proceedings. The other one, now this issue of voting, where you say the members of parliament, members of parliament sitting and voting, from beyond knowledge about constitutional interpretation. Any side where the constitution use a particular word and another one use that word then you not get the intention for make that word they apply.
Right.
If in different sections you don't say sitting and voting, then you say members of parliament, then not to the one where they sit on and vote. Now the full members of parliament. Me colleague give me an example of America. I not go through the American constitution on that area, but I go, now we don't bring and go research more. But one thing me know about, one time they vote to the 2/3 majority, they bring a senator, they fly am by helicopter, now in sick bed, bring and car inside, na for can vote. Do you understand? Because
Forget the
2/3. The whole idea about it is that you see the constitution, an important document. I've been there that I testified before the 1991 Constitutional Review Commission. It was there for a purpose, and I look the report and give. It was there for a purpose to make sure that to amend the constitution, every member of parliament, you understand, should be there. The whip should ensure that their members turn up because it's an important document. Not mean to say as an half of parliament who can't sit down and then you vote 2/3 on that. It is deliberate. And the constitution is deliberate in its wording.
Would it have been better or ideal for the speaker for ask the Supreme Court for interpret that section before then going to committee stage and vote on that thing? So the confusion of what they say is present because what in the speaker say what is sent so now for further elections.
It would have been ideal, but as I decided to tell you, so nothing in the constitution was that speaker. That they make law. You work for do, then give me your work for do. You make the law, me I interpret the law, you don't make condone. Well, you make cannot interfere. When we say they interpret, you don't interfere. You as an make we say a separation of powers. Each and every arm of government, they jealously guard in powers. You know, now interference around it. So because now we make the law. The constitution they ask the Supreme Court for now be making.
But
Parliament,
that's
they say Parliament bind the successor.
They said there's been confusion around it always.
Well, you go to and I would do so. You understand? Now they can't
to go on this.
APC then they go court. You understand on this? This is how it's done. You understand? APC then they go court on this. The president, as they rightly say, when I talk about treason, I don't talk about treason now. You understand? Because that's not be for make treason be, you know, because now this is not proposed. This is not proposed acts. Now in a bill, you understand? Until that president, I mean that's the day they change them to act. That's the way they go before the president. When you sign down an act, if you not sign and send them back, then they can't go print as back, then they can come back as bill.
Yeah.
You understand it? But it only turns to act when the president puts in assent. At that stage, if he put in assent, then this parliament, then find out say they're not going to get authority for alter the constitution, then that is treasonable. I want to make that clear.
Okay. Dr. Abdullah, quickly before I come to
Before you go to the next speaker, I want to make certain addition to what you say, and also it's really just what you said. What here I try to say from the onset today. Constitutional interpretations are subject to various interpretation based on, for example, which canon of interpretation you use. Yes, if you use textual interpretation, which is what most people are doing, you get a different interpretation. If they use harmonious interpretation or structural interpretation, it gives you something completely different. Now, it does not make you right or wrong. It does not make you unpatriotic or better than anybody. These opinions are supposed to exist. I can tell you, for example, when you read the Samsumana judgment, 5 judges, 5 different rules of interpretation. They all arrived at the same, right? Whether they do purposive, whether they use textual, whether they use originalist theory, it's fine. So I just wanted to make this so that we can understand that in terms of holistic interpretation, it does not give you a clear answer. I have also gone to the issue of comparative, that in constitutions, which they want to say all, or totalizing clause like its membership, like in Uganda, like in Kenya and Zimbabwe, they used it. In our constitution, they say the members of parliament. Now that does not say all. It's open to interpretation and why we the link. And I've also insisted that the Indians brought all of it together. But why I'm saying this is because if you look at the national prohibition cases, now a U.S. Supreme Court case, I'm going to quote exactly what they said. Look at Article 5 of the U.S. Supreme Court. It say the same language will get literally say both houses forget then for big 2/3 majority of both houses for pass a constitutional amendment. In the national prohibition cases, which in the Supreme Court says, it said the 2/3 vote in each house, which is required in proposing an amendment, is a vote of 2/3 of the members present, assuming the presence of a quorum, and not a vote of 2/3 of the entire membership present and absent. Now I refer all of you to that, but they did not just say that. They based this on another case called Missouri Pacific Railway versus Kansas, where they don't say the same ruling. You understand? This is the way the U.S. Supreme Court look at it. If you look at a case called Gonis, very recently, I think it's 2020 in Zimbabwe, they went completely on a different side. They say if you say 2/3 of the house, it means 2/3 of the entire house. Now, this is not the same language we get. You get different constitutional interpretation. In India, where they bring them together, they say 2/3 of the house means the entire house. They very clarify. You understand? So they've clarified the issue. My point is, we have canons of interpretation. We have the perspective from where we are coming from. Now the question is, can Parliament or the Constitution itself violate itself? Various provisions. If the Constitution says quorum to do business, it not say to do ordinary business. Quorum to do business. Now this, how did you change that when it comes to voting on constitutional matter when a business? Did the quorum change? Right? And I think Victor raised a very important point. If few people are not there without excuse, do you drop the bar in terms of when you have a 2/3? Do we also say on textual interpretation that, for example, the APC has seen that walking out will bring constitutional amendment to a halt, continues to do that forever? These are basically policy questions that you ask. But one of the other things which I wanted to add, and which I spoke about in our last program, is the issue of dialogue a national constitutional making, and I think everyone has made that point. And I also think Honorable Timbo made the point. We are so politicized that amending constitutions at this time, I said that the last time, it's not correct. Because now politics now we dey look at. Even if you agree with this change, you dey think about which is the way they hide we will not see. Which is the way the advantage this person will not see. You understand?
The politicization of the process.
Politicization. But when
And lack of
there's what we
justice
call
as well.
constitutional making and constitutional design. When you dey do constitutional design in transition country, this polarized country, these tensions are bound to occur because everyone is looking at waiting this go disadvantage, waiting go advantage. Because, for example, if you look at this PR system, both governments have amended, have suggested it with the different variations. We go fix them. So it's really about. I go back to my point where I don't make all throughout this debate. Let us agree on how we want to have our politics go forward in the 100 years.
Okay.
Let us depoliticize that conversation, if it's possible, in a way whereby if you have a president after 2028, let us put all of this amendment together, all of this constitution together, and amend it. The other point I want to make, which I disagree with Chuko on, and I disagree with Timbo on, and I also disagree with my landed senior here. This constitution has fundamental problems. Fundamental problems. What was she done? So the amendments are way we table. When APC and SLPP agree for amend, Iboku, do I want to agree at second reading? What Timbo said they vote on. Right? That night I've been not come home with and do that vote. They agree, say, this constitution got problem. Let amend all of these issues except the one who disagree. Apart from that, we have the pro-people part of it. We're not even did it. The socio-economic right aspect of things, the human right provisions part of this, you understand? They are not there. If you put all of that together, it makes the constitution wanting. What means say, we go back to the TRC report. We say, one of the things we need for do short term, medium term, and long term is to holistically review this constitution.
Okay.
He put sorry, before you done, then we go to Justice Kawan. He gave 134 points to amend the constitution. When I be 80-man committee, we can't to tripartite. We are amending it by piecemeal. So there is a need, as much as we agree on the politics now, we disagree on the politics now. One thing we all have agreed on, or we may agree on, is the need to amend this constitution without it being a political debate.
Amending it is even a problem now. Emeka, I want to ask quickly as we try to conclude this conversation. In amending this constitution, what is clear in the process with the process in Parliament? Is it 2/3 or simple majority?
No, I mean
the rule just now.
108 clear a 2/3 majority. If you want to amend the constitution, you want to put a new constitution, or you want to amend any part of the constitution, any provision, you need a 2/3 majority of members of parliament. And there's no doubt not about that. Now, just for what Emmanuel, Dr. Safabula, I say, I don't work with this book here for the last 20 odd years. And most of me, where I've been the Human Rights Clinic, where I've been the NCD, where the PPRC, I've studied this book. Okay? Now, I'm not saying a perfect book, and I'm sure said Mr. Honorable Timbo not say so at all. What me say, we can amend the America they do. They get the constitution, they get amendment to the constitution, not to 40 something they don't get now, 48 or something amendment. So we can amend them piecemeal when problem arise. Like one problem that arises, Mr. Banja Tijasi say, is that how the Supreme Court for interpret 2/3 majority in parliament, whether or in or out. That kind of point say, if we think say get out, why would not go to the Supreme Court get an opinion? Then it go inform how parliament react later, and then they change the law. But this holistic thing, not about for change this. That political persuasion we try for or political expediency. Now they try for achieve if one do on that. This is not a problem. No change from 55 to 51. 55 to 51. What's 55? Whose problem 55 with the GUI? As a people? Whose problem 55 with the GUI as a people? We talk about the threshold.
Yeah.
The only reason why for change them that because we look say don't make things easier for the political elites. Okay, but no cause with no problem, no cause with the people, no problem at all. So the provision itself, not a problem. Now beyond choice, and a group of people and choice now want for change. When we talk about the human rights provisions and the fundamental human rights, what do we get? One move to a communist kind of constitution, or one move to a socialist kind of constitution? A constitutional provision, they're very clear. These are the fundamental principles of state policy. Government for do A, B, C, D.
So it didn't be even before.
But you want to make it be justiciable. You want to make Pekin where Sidom now decide say they go school. They get to sue government, say pow government for their education or for their hosts. Now that's want. If you want to want, well, by all means you can amend them. But for us, we say, whether as a people, we don't move away from where we were, and we want to move forward. We want to get change. For example, the constitution clear. When you appoint you chief justice, I let this justice example. It got to be in consultation. The president they appoint in consultation with the Judicial and Legal Service Commission. So the initiative for come out from where the Judicial and Legal Service in Commission. So me interpret them. And then the president gets a function where they act on the recommendation of the Judicial and Legal Service Commission and appoint the CJ. Now, for the last 3 CJs, I know the hear that. How would they see presidents at this I want, or the executive at this I want, and so it be? So how we want them for be? We've asked myself as a people.
So it's about the interpretation, not
interpretation.
action.
Even on that, we, Mr. Emeka says so. One of the things I don't research extensively on is judicial independence. And even that Judicial and Legal Service Commission, now what are they? Look at the composition of the Judicial and Legal Service. I mean, you go no say they will never be independent. Now, waiting the government tell them. You know, the head of the civil service, you get the chief justice.
No, I disagree.
You understand? So the composition in itself makes it more prone to establishment, to the dictates of the establishment. You understand? So the point.
So I don't cut to because then I not make them they go because I disagree fundamentally. The composition of the Judicial and Legal Service Commission, okay, makes it stringent for make we able to do anything with them. The chief
has that been the case?
Wait. Now depends on who that are the people. The Chief Justice, okay, of the Republic of Sierra Leone, for being a man without reproach.
Yes.
When he sit down, nobody nothing for influencer. So that's the first premise. The next person on that Judicial Legal Service Commission, not to any Supreme Court judge. Now the president of the Court of Appeal will not therefore be affected positively or negatively by the decision of that country. So really, the founders of the Constitution,
Mr. Taylor,
they give a much thought.
Mr. Taylor, let's get this conversation about this. Because even before you get to the president of the what is it called, of the Court of Appeal, we all know how these promotions are made. So I want to get this conversation from all.
Honorable Timbo, I'm sure you don't take note. There are things where you want to clarify and want give you an input on. I see you've been the type for make points on them. You get the flow now.
You know, go Boku. I just want to say, I left here so happy, man. I don't get a lot of conversation on this constitutional amendments bill, but mostly with politicians and people who don't really understand. You know, and here we have 100% of lawyers talking about this. All man get different opinion, which is fine. The ultimate person will get the power for interpreting at the court, the Supreme Court. So that is fine. But one thing we nobody not disagree with, that for amend this constitution under section 108 they did. And section 108 say that 2/3 of the members of parliament now supposed for do.
That is agreed.
So anybody will say they amend the constitution under section 91, is wrong. So if speaker right say under section 91 and 108 only apply to amending section 108, it shows a problem been there under. You know, so that is something I'm happy for. Again, with waiting Chuku say, what we don't they say before, me this constitution, I no get problem with them. Mortal man, I will get problem no more. Who they do things for suit we self. If you say Chief Justice, na Judicial and Legal Service Commission, now for do the process of identifying and maybe shortlisting and recommending to the president. Polo do. If you say for consult for God for be electoral commissioner, not just rise to me so you don't consult me. Where you want for be mischievous. Now the interpreter in a way for make problems come. Consult, call the local sit down. How for pick this electoral commissioner? But you say, no, I don't write to you. Now consult, I don't consult. How can that be consultation? This constitution, none in the world is perfect. We just want to talk about what, 40 something amendments in America. The one in England are small bits and pieces there. Then they get after the Magna Carta.
They don't write themselves.
They don't write. They're not
The constitution
writers.
not written itself.
You know, they. Why one for can make boku thing over nothing? The day we implement, we'll do a new constitution for with the Monkawan thing. The very day we start for implement them, you will see interpretation problems. Definitely.
Is it
I
safe
don't
to
write
say?
party constitution.
Yeah.
We don't create all kinds of safeguards for no waiting happen with some man not happen again. Waiting me they happen when they say selection. No, where are they inside that party day? They say that the worst constitution, this, because you don't block people from doing what they do before.
So it's interpretation.
It's just
and
people. It's just people. So me, I'm just happy. 108 na two thoughts that I require. Yeah.
You going to court, or the parties have said and they go court? Are you filing together or you just file separately?
We're going to court. We're going to court and we're going to court.
On what grounds? I've been asking that question.
On many
there.
grounds. Maybe interpretation first of the constitution and also on the ruling of the speaker. So now two different issues actually.
You going to court with your party or you dey go separately?
I've been telling you sir they behind the party, so we're going together.
Okay.
Yes.
We can't close, but quickly, Elinor, waiting are you closing on this? Your closing statement on the conversation we only look up to. I think we will get post Supreme Court ruling on this. We'll get a conversation on them after the ruling at Supreme Court. But waiting are you closing statements on this? How can call an a court? Closing argument. You closing argument.
Sorry, what you begin.
Anyway, closing argument, please.
Yes. Quickly before I give me closing arguments, I just want for say I appreciate that we they come with comparative examples. That's Dr. Abdullah, you don't come with comparative examples, but again for also recognize say all the example and way it don't give now the Supreme Court or the highest courts now that country they don't make an interpretation on constitutional provisions. Not so that we get right now. We get a situation where rather than case law based on judicial interpretation, we get a speaker of parliament where don't do the interpretation, where you don't get the power for do under the constitution. So let we ensure say for the listening public, we understand the difference and that yes, different canons of interpretation go apply, but who that they do that interpretation they matter. And we need for ensure say now the courts we don't get the power for do that, now then they interpret not to other authority them. And then I also agree partly with me brother Mr. Taylor disagree on whether or not we need for amend this constitution. And we obviously see say interpretation issues and there, and also issues that around whether or not waiting members mean whether or not 2/3 for clarify with whether 2/3 needed at a committee stage or not. So yes, need for change or get their interpretation in the and then they for be part of us rather than them fetting between political parties for consolidated power through electoral systems. But
Okay.
I also agree with Dr. Abdullah say
Okay, I think we dey get network
from
problem.
real perspective
Okay,
as people.
go ahead, Elinor.
And so there issues and they around justiciability of socio-economic rights. Now there I get for disagree with Mr. Taylor. Then thing and they fundamental to we as people as ordinary citizens, not so to the political elite. And it important for we any constitutional amendment address the issues then they, and not to just for focus on the things and we get for consolidate power. Then they plus the for let the courts and clarify on the interpretation issues now the way forward.
Okay, thank you so much, Elino. Victor, quickly and finally.
Yes, thank you very much. Well, we don't agree say the Supreme Court gets the jurisdiction, the power for interpret the Constitution, including waiting the ruling of Speaker, because clearly the section we would refer to for say the Supreme Court no get powers or that the Speaker gets the ultimate power. No, I mean it's very clear that as far as it not got to do with the rules of procedure, we Parliament they use, the Supreme Court will always intervene. But then over and above everything, I think say my own disappointment at the fact say it's highly unlikely now for the current president for let he go able to take through the entirety of the constitutional review process. Because now, after this stage, it's much more about elections. I mean, you know how elections can be in this country. So I expected that during the tenure of the presidency, of this current presidency, if not able to pass a new constitution, we will take care of several emerging issues, and particularly so that section 14 within the constitution, we make socio-economic rights then, not justiciable. Now something we need for actually address because an empty bag cannot stand. And when we make a position, we have to really think of the down to them. All of this amendment do so. I mean, over time, we have not been able to actually address the economic issues them where we get to this country. That should be the soft amendment. But
Okay.
unfortunately, we don't forget an opportunity under this presidency for us to get a brand new constitution. We will actually amend or change that section 14 where it talks say you cannot take government to court when government is unable to provide socio-economic enlightenment, those basic amenities. And under international human rights law, we get the basic minimum core. Basic minimum core now in every government for able to provide. So if we are many constitutions, if we are altering constitution, we will always make sure say we think of the ordinary man. What we don't do so right now, mostly will actually just benefit the Timbos of this world, the Manchester Ablets of this world, where they try to come to power. The politicians. And we are better for the ordinary man in the village. So that is what we should actually
That's a good one, Victor. By the way, Victor, then we other studio, we studio 3 with dark room. It is the building, yes. So Victor, not on our side. Not on our side, please. Then, but we dey close now. I just want to close with this statement from Francis Ben Kaifala, the Anti-Corruption Commissioner. I just posted on Facebook 23 minutes ago. It's a dangerously educated opinion. After hearing all sides, the Supreme Court must decide not to decide. Perfectly lawful. I don't understand what you mean. Possibly we'll get your side of this conversation on this. But to the close with we learned colleagues at the studio. Mr. Suleiman Banja Tijansi. I'm sure the Supreme Court will be busy. APC get for go then get the interpretation for the speaker as well. The president not getting assent it. As a senior citizen of this country, waiting go be your word of advice and waiting the public for expect at a time like this.
My first advice now to the president. Now the custodian of the law in this country. Now man we get good democratic credentials in the sense that 1996 now hand over power to a democratically elected government. And I believe say do that because he believe in the Constitution of Sierra Leone 1991. Media advice and you are making rolling pen may not give assent to this bill and allow the judicial process for go on. May we determine the issues there before you do that. That nine are my advice to the president. Because now I get all things on this.
Okay. Thank you so much, Sulaiman Banja Tijansi, for joining us this morning. Dr. Emmanuel Safa Abdullahi.
So thank you very much. So just before I give me parting words, to me, sister and colleague Eleanor, I not say the speaker and I do ruling. And we all understand that we forgo Supreme Court. Even the speaker says in his so-called ruling, he say we forgo Supreme Court for interpretation. The courts now are the ultimate decider, and I think a couple of colleagues and don't make the same points. Now, yeah. What you would try for give is various opinions on how this interpretation for them be and how they for implement them. And as you said, and I said earlier, the canons of interpretation, depending on which school of thought you come out in the legal stuff, gives you a different interpretation of all of those provisions. 108 we all agree on, 91 we agree on, including whether it can be structural with 89. This is different. So for me, I have said my part in words were very clear. This is a constitutional making process. We need for consult, we need for agree, we need for be much more thoughtful, pensive about this, rather than just being political. I adopt within my senior colleague have said the president has to listen and go through this before he take the next line of action. And also we all as a people get to realize that democratic space means disagreeing. But what we don't get over the last 30 years is that this constitution needs reform. It needs to be reformed. Whether we amend them 50 times or one for one holistically, like what the Edmund Cowan Commission been say, or like how the TRC report say, it's up to us. But even just all of this disagreement means things and they will need for tweak for making clearer, like what the Indians then do.
Okay.
So this is a very good democratic process. And I also finally, I very appreciate the fact that firstly the APC is going to the Supreme Court. They have again restored trust in the judiciary, which initially they said they were not, which undermines even our own democracy. It also puts a lot of onus and responsibility on the judiciary and the Supreme Court now to say people are coming back to you, restore the confidence which they had lost in you. Thank you.
So you can see you sure the judiciary will restore its confidence, the trust, the public trust?
Well, this is not an opportunity for do that. This is not a great opportunity for do that because this is not a burning issue. And I wish them would look at from a national point of view and according to the law. Let them interpret the law and make them not listen to any. We all have views no more with the Guinea. Now them, the constituency for interpret the law, make them interpret them with no partisan lens.
Okay.
But the people of Sierra Leone and the constitution before them.
Emeka, your closing argument, closing statement?
The matter not going at the Supreme Court yet. Perhaps it's not going to even go this. But one thing I'm sure of is that the president will be a listening one. He will see the views of so many of us will be expressed that if we're holding pen for now. And that if you want for Luca, he can send and go back. And he can change the tide of events will go happen in this country by in pen and in refusal. So my own urging really, now for make we all continue for play we own part in the democratic space. Those of who are not a politician, because as I say, I'm not gonna dog in this fight, except for the constitution. I like this book.
Yeah.
So we always a part of the civil space. Look, do we own try to educate the public. And I make you know, sir, I go to come.
Yeah.
When you call me for lending me on understanding, okay, to the constitution, because I cannot interpret them.
You know, we residents.
And to be honest, this discussion will be very helpful to me today. I mean, especially for Honorable Timbo in perspective, because if you notice on the last appearance where they make now give out Honorable give out the quote. Now no more be the talk from the legal side, and waiting Honorable Timbo no explain will not get in time. Now Honorable give out interpretation of 44 of the standing order. I think 44 we give the speaker an power for for compute the 2/3 majority in instances where absenteeism come in. Okay, I not agree with Honorable Givawa at all. I mean the provision we use and with I may read them.
He said he's very happy that in friend Honorable Timbo they go court.
But I'm collect for make at least I get that perspective. So next to the court, I was Honorable Givawa say, Honorable Timbo say. So but because my own view, I don't hear everything Honorable Givawa say, I don't agree with him.
Yeah.
Okay, he said the speaker can compute. So if you absent and you travel for out of the country, you don't take leave of them. If they calculate the 2/3 majority, so for example, at 149, the 3 people from APC will absent themselves.
Yeah.
They can say in reduce that number to 146 and take 2/3 of 146 to arrive at the 2/3 majority.
Okay.
That's not in the constitution, but it say it's supported by 44
Then standing
of
order.
the standing order.
Okay.
Okay, wait, the rules of procedure. So, but circumstances under 44 museum now where you get like a state of emergency.
Okay.
So I'm not going to generalize them for all circumstances. So me don't know what's the
Honorable Timbo to clarify that.
yeah. So that creates a new one.
Yeah.
So at least I can put this thing to rest. Commission don't tire.
You think say this where they happen, so they go Supreme Court now. It could help in the judiciary regaining its public. You know, the Samsumana issue always they come up.
well, as Mr. Tijansi say, the judiciary can get for be tested. Okay, and now this current judicial dispensation not be tested yet. In some Sumana case, they were really tested. I mean, on that view there, and rightly or wrongly so, some of you don't even write book on the decision. I mean, in terms of the critique, we'll take off them. I mean, we're not agree or without you, but they are the wise men. And some Sumana ruling, what it did to us as a country. I mean, even Mr. Abulago say, it sets a pace for judicial interpretation. Okay, so now the current vogue by the Supreme Court for be a holistic approach. We now look one section. I mean, the original approach will be happen during the Samsumana instance or even the Eke Holloway trial is that the court will say you take the section as it is. You look the section. Or they get this issue about the Attorney General, whether he need for get parliamentary approval or not. I mean, the Bar Association take that case to the Supreme Court for interpretation. And the answer was section 64 of the Constitution, that standalone. They make a specific provision for the Attorney General, Minister of Justice. He's not an ordinary minister. So you look at that section with myopic eyes, and that section you for watch. The Bar Association argument was once you say that a minister, if you look other provision where they deal with ministerial position. So that was the approach then. Then came Samsumana, where the court say, well, we'll go look all of these things, we'll look all the sections there, we'll bring them together and make a decision. That's the approach where the speaker will attempt for use in a ruling. So it might be a good test case now. Let's go back to the Supreme Court. Let's switch approach for use. So I want to come go let for there as a scholar back. We go write the book.
Inshallah. Honorable Timbo, you go just clarify as to the close and you give you parting statement.
Clarify on
The standing order way.
standing order.
Yeah, we talk about.
44 talk about MPs that would not even die. How for compute these 2/3. I just read part of one. And in determining the 2/3 majority of all members of the House, pursuant to subsection 6 of the interpretive section 30 of the Constitution, account shall only be taken of the persons actually and validly existing as members of Parliament at the relevant time. In recognizing only living members of Parliament at the particular time, blah blah blah, as opposed to the one that we don't travel out. Well, sometimes if give out, say down they don't go, don't die. He left travel.
No, the point is the speaker get power under the SOP
Yes.
for compute waiting at the 2/3 majority.
Yeah.
You
Yeah.
can't take that away. So if he be only just say in a rule in your view,
Yeah.
say we don't come to this voting stage,
Yes.
we get a 2/3 majority of the House, we me compute as ABC, I take account of the 3 APC members we don't go. The narrative and discussion for different today.
I think
But
that-
the source I go wrong, that way go use the
and now they don't
the
come
simple
under
majority.
the rules of procedure. If that's so been do computing the number of who are present, who are not present, okay, we will get our arguments. It's a different argument. But for saying under 91, that's totally something we.
The APC get trust in the judiciary now.
It's not a matter of trust. The last time I sit there, I've been telling you, say I don't even trust myself. You know, but the law day. Now we need for Fala. So we're going to test it. You know, and we believe, say, the people where they're not there as Justice Emmanuel Safa Abdullahi. They're there as judges of the Supreme Court of Sierra Leone.
Okay.
So we're expecting them for doing it right in line with the law.
Okay.
I also want for finally say a very big thank you to my colleague members of Parliament on the APC side. for walking out of parliament when a part of the constitutional right, a part of parliamentary process, and I not feel it should be inquired into because
But you can be kind to the speaker.
the reason why now because now we don't wait for show with dissension, now we don't wait for vote.
Fair enough.
So we walked out on what we believe, and like we talk about participant criminals. If this not treasonous act, nobody no go hold Abdul Kagbo and his soldiers for walking out of parliament. And then nobody, like how do you hear the two people and other people arguing? They're making this as if the point or the biggest issue is APC is walking out. It is not.
No, it's not.
The biggest issue now whether they properly pass this constitution or not. But listen, the Human Rights Commission man appointed by the president saying that, oh, now the tell worker will come out at the time will not for come out. Listen, Elino and other people saying the same thing. So let people
make ourselves agree. Say
yes, I'm not going to call his name. I mean,
This one just give me one more bite. Because I see they put a flyer out on me APC on AYV program yesterday. Where the of all what I say, the thing they highlight that the fact I say APC left way at the time we needed them the most. Me public education drive not for condemn the action of APC. It was a pointed question where they asked me, and I answered pointedly my own view as a citizen. What thing I cut out or edit?
And the voter.
And the voter, yes. What I edit from was the question and the context. I say I know they invalidate the feeling and the rationale. So just to make Timbo be comfortable,
okay.
let Timbo be comfortable, then feeling and the rationale for working out, not to me game point. My game point was the question of how I feel like a citizen. So then they disappoint me as a citizen. I mean we not agree on that, but it not invalidate the substance of what I say is that 108 of the constitution was not followed.
Okay.
And that process there was flawed. I don't talk about the second reading. I don't talk about.
And if the president give assent, it could be.
If the president give the assent, an important back say I don't agree with the flyers out about treason don't be committed, etc. I say that threshold go be met. Go be met.
Yeah.
Okay. If at all, they suspend the constitution, they alter the constitution or they repeal them, and that will be done when the president puts his signature.
Okay. Finally,
yeah. So I think I don't clear this point where he say then disappointed because we not represent the people.
Yeah.
The cipher debate we debated stoutly.
Yeah.
We debate. We do all what we for do. And we come and vote. Now so now for be part of treason. That they make we come out.
Okay.
Thanks to Honorable Abdul Kagbo and the leadership of the APC in Parliament for taking that decision and leading we out of Parliament at the right time.
Okay.
And that is not the issue here. The issue now whether they properly amend this constitution according to what in this constitution provide.
Thank you so much, Honorable Abdul Timbo. Thank you, Chukwuemeka Taylor. We resident legal expert. Thanks for the education. You man can message me. Try bring come Chukwuemeka later explain. But we appreciate your time. We appreciate your time so much. Thank you so much, Dr. Emmanuel Safa Abdullah. I know you were traveling late at night and you make come now. We appreciate that so much for this public education. Mr. Suleiman Banjati, thank you so much. This is the right time. I know I've been asking Walika, I say no, wait for the right time. And I appreciate that this is not the right time. And thanks for gracefully lending out I call myself.
Clerk of Parliament.
No.
Supreme Court, the president of the Supreme Court.
No, for today, me not the judge. For today, I hope they not go hold me for impersonation.
I see you wear suit all man.
Yeah, I suited up today for this session.
We get down because
No, it's my day. It's my day.
Intimidate people.
No, it's not
You know what I you.
And look me say, what would Timbo say? Same thoughts.
It's my day. Thank you so much. Thank you, Elina. Thank you, Victor, for joining us. This conversation, they continue. There are many aspects to it. So they continue with the goal and public education. Why help people understand what's in the happen. And we can get the political disagreement and go happen. But there's something we all together. Now salon in progress one, how we make this country a better place, and we all get the opportunity for doing now another whole day they play. So meet back tomorrow, have a lovely day and continue for stay with media. Me now you legal expert, untrained and unqualified lawyer, Amadou Lamgana Baba bye.
We go vote am for sure. APC, we dey ready for change. The youngest na the whole. We future go arrange, che, che, che.